Sure.
So we can have the option of having both plans, we don't have to choose one or the other. We can have one or the other, and then say like a person like me who has pre-existing health conditions, I can buy the buyout plan, and the city can still pay the $9.69, and then I'll pay the rest.
That's correct.
But somebody who doesn't go to the doctor as much as me, who say like maybe Nick, who's not as sick as me, he can go with the base plan where the city pays the whole thing.
Yes, ma'am. And the premiums that the individual would pay, you know, if they have to take the buyout plan, those would be pre-tax. You'd save, you know, roughly 25–30% on that money. They would see the 35–20, you know, on their payroll deductions, but the net impact would be, you know, just say 25–30% less on that, depending on tax brackets. So their payroll, their employee, their insurance deductions would come out pre-tax. So if they make $100, you know, they're only taxed on 65. I look back, it looked like as early as 2020, I think y'all had something similar to this, maybe a year or two. 19, at some point, they offered two different plans just due to the price increase. And we did away with it a couple years back, and now, you know, we're faced with it again, just with the rising cost of healthcare.
Okay, but just to be sure, I'm looking at this sheet now, just to be sure. Okay, the first plan is the same thing that everybody has right now, where they're paying nothing.
That's gonna be the base plan.
The base plan, right. And if somebody wants to go up and to get, they'll have to do the number two, the plan two buy up, which would be $35.20 out of their check each week, which amounts to $152.55.
That's correct, yes, ma'am.
Okay, so that's if you need more coverage to do the buy up, and if you don't, stay where you are. That's how I explained it to the guys and that we talked to them. I think only one chose the buy up out of the group I talked with.
Okay.
So I was just trying to make it a little simpler. Basically what it is.
That's right. And it's not uncommon. We've got some groups that offer 3 or 4 different plans, and it's,
Yeah. Anybody got any questions here about the insurance? And if you want to change, you know, when you get your packets, that'll be when you decide that when they decide, decide today if you need to buy up or that you got the two options.
I just think that the majority of the employees are gonna go with that zero. The very first one.
You have two options.
Yeah, that's what I'm saying, so, but I'm just thinking that the majority of employees are gonna go with that first option right there. But if you wanted to go up to something higher, whatever, I just don't, I know $35.20 may sound like a little to some people. But then again, for a lot of them, I think that could add up for the difference between from buying groceries just about
that's right.
in a paycheck. And,
But it is pre-tax, so it won't be exactly 35 out of their check each week. It'll wind up being more like 28, or it depends on the tax bracket that they're in. It'll be more like 28 a week out.
And the one thing we have to look at too is, you know, the free stuff's gonna slowly be going away. We can't continue to do that as shown by our budgets. We don't have the money and where we are with our other things, but, it's not, you know, and hopefully we'll finish the budget we're on now by next week or the next one, and we'll get our grants. We'll be back in good shape again, and like I say, hopefully get raises for these people, and they won't miss it for long. And that's not a lot. I mean, $28 a week to me for the kind of insurance coverage they've got here, it's not a bad deal at all. And they all understood it, and like I said, it was just mostly the young people that's gonna stay where they are because they don't have any medical issues. Older people did, like, you know, go over.
That's right.
So it's just an option. If they want to, they can. If they don't have to.
So the $969.33 that the city's contributing, that's monthly?
Yes, sir.
Right.
Yes.
What were we paying before?
10.64.
which is not a whole lot different from that. Yeah, which is not a whole lot different from that, but I do know that having looked at the budgets before previously, insurance is a big, it puts a really big hurt on the city, it does.
And absolutely where we are in our audit, Ms. Carolyn, that's exactly what they were saying, is that the budgets aren't reflecting what we're actually kicking out. It was a whole lot more than what was originally thought.
And when we sheared the budgets up, Ken and I back here, some months ago, the budgets did not depict at all, the previous budgets did not depict what was actually coming out for insurance, and it was a big hit. But I just know that, like, the mayor said that maybe eventually when we get straightened out with some of this stuff or whatever it is, but I do know that even at the 969 is a lot still, that we're gonna have to shear the budgets up with. But, it is
And
what
just
it
to
is.
tell y'all what the staff response was, those who know that they had medical conditions didn't have a problem with the $35. We encourage those who don't have medical issues. Some of the issues that we figured out, even through the audit numbers, is the reason why our numbers may be increasing or where they are, is our people are not going to the doctor, like they're not going for, and those other stuff, so, right, so they're not paying into the insurance by not paying copay and other stuff that is a guesstimate of what we would have spent, so we're not spending money there. So those of us who do go, we didn't mind kicking in $35 a week if it meant we was gonna keep the health insurance. Like, I have TRICARE, which was one of the best insurances, but they won't pay for diabetic medication, but our insurance will.
So how many do we have to have to actually, as a city employees, to make sure they're the group insurance?
2 individuals will make a group, but, it's based on participation, and historically, your cities and counties have higher utilization. You've got individuals that start out working here when they're 18, 20 years old, they'll work here till their retirement age. And so your average ages are normally higher in this industry. Utilization always seems to be higher too, so it's,
I just want to ask it also too, so if we had employees who chose to do the market help market, if we lose someone, if they went over to the help marketplace, would that cause our insurance still?
you're a small employer, so, really, you're not impacted by that, but you do offer affordable health insurance, so if you deem it affordable, technically they're not eligible, but, I've seen some individuals that their tax returns have certainly been impacted on the marketplace, for sure.
Say your base plan, what if your insurance, as far as premium, not premiums, but your deductibles and co-pays, what?
It's that $4,500 deductible, and it's pays 20% after that, I believe. Yeah, 20% after that, so your max out of pocket $7,000. Office visits for primary care are 30, specialists are 70. That's just like they are now. Same drug card as well. $10 for generic, 60 for brand name, 90 for your tier 3, and your tier 4 is 20%. Max is $250, I believe.
Well, they're paying a higher deductible.
Yes, sir.
Before, so.
No?
If you look at the worst case scenario, they're gonna be better off going on the buy plan. But if you're looking at somebody that's, never goes to the doctor, they're certainly gonna save money by, not having to pay any premium. If they do go for your minor stuff, they'll have office visit copays and drug copays, so it's the catastrophic situations is where they would get into that deductible and out of pocket diagnostic procedures.
What's the maximum out of pocket for the buyout?
Buyout is $3,500.
Okay.
But there's no co-insurance there, so you have a major procedure, you know, April 2nd, you're gonna meet that $1,500, and then you're just gonna pay 100% after that, but you'll still have office visit copays and drug copays to satisfy the difference in that out-of-pocket and deductible. Deductible is included in those out-of-pocket numbers.
Okay.
That's the 1,500.
Yes, ma'am.
What if we change that 35 to the 25 that we talked about at one time?
To a $2,500 deductible?
What would the final numbers be on that?
The complicated thing about this is Blue Cross, they have their standard plans. It's hard, you can't create your own plan, so to speak. Once you do that 2,500, it goes to, let's see. It's a 1,500, then the next would be 3,750. And that's 80% after that. The 100% plan is, that they offer is pretty much, that's the best plan they offer. It doesn't really, the next would be a HSA type plan where it's a, you know, $5,000 or $6,000 deductible, and it would pay 100%, but you don't have office visit copays and drug copays. They really limit you on the number of plans that they offer, and it's, you know, it's all through the chamber. So it's,
Well, I guess we don't have much of a choice here but to move forward in regards to that, and, to know that those, who want something different, pay $35.20 for those, am I correct with that? And then the others, it would just be zero.
yes, ma'am.
So that's the only thing I guess we can do, but just know, I mean, we know that this has been part of the problem with these budgets anyhow, it's the insurance that is eating these budgets up. And we just, I mean, and we gotta make sure that the employees do have insurance, we offer them some type of insurance. So, that's some of the things that we're gonna have to look at. Because, I mean, in the past, the budgets never did reflect what the actual insurance, that we were paying for the insurance. And it was astronomically high. But if we can get it to the extent that some folks wouldn't have to pay anything, we don't have any other choice. We're just gonna have to try to get some money from somewhere.
Some of these other plans, I kind of picked the plans that made the most sense to me. Some of these plans, you may have to meet your deductible, your medical deductible first before your co-pays kick in for drugs. So I didn't think that would be very appealing to y'all, or certainly the employees, if they had a, you know, $75 drug where it would be a, you know, generic copay. They had to pay $70 first, and then they go towards their overall deductible. So I don't think that's a good fit for y'all this time, for sure.
How many covered employees we got?
I think it's 14.
Yeah.
14 total?
Yes, sir.
Well, the only thing, I'll say again is that for those who feel like they can't, you know, they may on the search, they get on the marketplace. We don't have to, you know.
The thing about the marketplace, you may, depending on if they qualify or not for any subsidy, the plans and networks are certainly gonna be better through the group. I've heard some horror stories that, there are some providers. I had one gentleman that came off a smaller group, being treated for cancer. His cancer doctor told him that you can't see him anymore because the insurance company was not paying him.
But I can also say too, that I know some folk who have, have done the marketplace, and it's doing well.
It works
for
out,
them.
yes, ma'am.
It works out well for them, I'm just saying that, we're tossing out options here, And, for those who feel like that they may not be able to afford it, they can research that, and that's what I was asking you, that we're not gonna be able, with the penalty of fine, someone saying that, I'm not gonna buy into the insurance or whatever. But, I mean, they gotta look out for themselves as well.
Yes, ma'am, and having a zero weekly peril, I mean, it's certainly affordable for everybody and
Yeah, but it's still, what I'm saying, it's still, it's a pretty
out of
good,
pocket, yes, ma'am.
it's a pretty good amount for the city.
Yes, ma'am.
What is it, about $13,000 a month or whatever, yeah.
13,570.
Yeah, and that's a lot, it's a lot, yeah. It's a lot. But, people do what they gotta do,
That's right.
and then, but, we can't expect employees to work with no insurance. So I offer a motion that we just proceed with it with the options here. And then, and for those who feel like that they can't, or whatever it is, and, they do have the autonomy that they can search for themselves. Offer a motion.
A second.
Okay, we have a first and a second, all those in favor?
Aye.
All right, so carries then.
Okay.
You gotta have the vote there. You need to ask if anybody opposed.
Is anybody opposed? I didn't. The only ones here.
That's on the phone.
Oh, Doug's on the phone.
Well, you don't oppose, do you?
You better be up.
He said aye.
I didn't hear him, that's why
Yeah, I forgot that he should be up here. Anyway, Doug, okay. Thank you, Mike.
Yes, ma'am.
I know this was last minute for you, and I appreciate you coming over today to
No problem.
explain it to us. And now they have a choice of what to do, and we're good.
Yes, ma'am. Good. I'll get election forms and.
We got like a little turnaround time.
Be here Thursday.
Okay.
That'll work.
That work.
I'll get with you next time. That's okay. Okay. Thank y'all. Y'all have a good evening. All right, thank you.
And, I guess we get to go to the fun part.
Oh, boy, okay. I'm going to read this pretty fast. If anybody has any questions, shoot your hand up and we'll stop and I'll slow down. Otherwise, we'll be here until midnight. The first ordinance, we're reading ordinances as required by the code, proposed modifications to ordinances. The first one is the City of Reidsville derelict property ordinance. Be it ordained by the mayor and council of the City of Reidsville, Tattnall County, Georgia, as follows. Section 1, Chapter 24, Article 3 of the Municipal Code of the City of Reidsville is amended by adding a new division to be numbered Division 4, which shall include the following language and shall replace current division, Chapter 24, Article 3, Division 4, Article 4. Section 24, 181, short title. This article shall be known as the City of Reidsville derelict property ordinance. Section 24, 182, definitions. Is used in this article the term A, applicable codes means any optional housing or abatement standard provided in OCGA Title 8, Chapter 2 is adopted by ordinance or operation of law, or other property maintenance standards is adopted by ordinance or operation of law or general nuisance law relative to the safe use of real property, any fire or fire safety code as provided for in OCGA Title 25, Chapter 2, and any building codes adopted by local ordinance prior to October 1st, 1991, or the minimum standard codes provided in OCGA Title 8, Chapter 2 after October 1st, 1991, provided that such building or minimum standard codes for real property improvements shall be deemed to mean those building or minimum standard codes in existence at the time such real property improvements were constructed unless otherwise provided by law. B, closing means causing a dwelling, building, or structure to be vacated and secured against unauthorized entry. C, drug crime means an act which is a violation of OCGA Title 16, Chapter 13, Article 2, known as the Georgia Controlled Substance Act. D, dwelling, buildings, or structures means any building or structure or part thereof used or occupied for human habitation or commercial, industrial, or business uses, or intended to be so used, and includes any outhouses, improvements, and appurtenances belonging thereto or usually enjoyed therewith, and also includes any building or structure of any design as used in this article. The term dwellings, buildings, or structures shall not mean or include any farm, any building or structure located on a farm, or any agricultural facility or other building or structure used for production, growing, raising, harvesting, storage, or processing of crops, livestock, poultry, or other farm products. Graffiti means any inscriptions, words, pictures, paintings, or other defacements that are written, marked, etched, scratched, engraved, drawn, painted, or engraved on, or otherwise affixed to any surface of public or private property by means of any aerosol paint container, raw tip marker, gun, label, paint stick, graffiti stick, etching equipment, brush, or any other device capable of scarring or leaving a visible mark on any prior surface without prior authorization from the owner or occupant of the property. F, governing authority means the city council of the city of Reidsville, Georgia. G, interested party means 1, the owner, 2, persons in possession of said property and premises. 3, those parties having an interest in the property is revealed by a certification of title to the property when conducted in accordance with the title standards of the State Bar of Georgia. 4, those parties having filed a notice in accordance with OCGA section 48.9, and 5, any other party having an interest in the property whose identity and address are reasonably ascertained from the records of the municipality or records maintained in the county courthouse or by the clerk of court, provided, however, interested parties shall not include the holder of the benefit or burden of any easement or right of way whose interest is properly recorded, which interest shall remain unaffected. H, municipality means city of Reidsville, Georgia. I, owner means the holder of the title and fee simple in every mortgagee of record. J, public authority means any member of the governing authority, any director of a public housing authority, or any officer who is in charge of any department or branch of government, municipal, county, or state regarding to health, fire, life, safety, building regulations, or other activities concerning dwellings, buildings, structures, use of private property of the city. K, public officer means the city mayor, who is authorized to exercise the powers prescribed by the article, and any officer or employee of the city to whom he or she delegates such authority. L, repair means altering or improving a dwelling, building, or structure so as to bring the structure into compliance with the applicable codes in the jurisdiction where the property is located, and the cleaning or removal of debris, trash, and other materials present and accumulated which create a health or safety hazard in or about any dwelling, building, or structure. M, resident means any person residing in the jurisdiction where the property is located, or an owner after the day on which the alleged nuisance arose. Section 24-183, duty of owners of real property and structures thereon. It is the duty of the owner of every dwelling, building, structure, or private property within the jurisdiction to construct and maintain such dwelling, building, structure, or property in conformance with applicable codes and enforced within the city and such laws and ordinances which regulate and prohibit activities on private property and which declare it to be a public nuisance to construct or maintain any dwelling, building, structure, or use private property in violation of such laws, codes, or ordinances. Section 24-184, declaration of public nuisance. Every dwelling, building, or structure within the city which is constructed and maintained in violation of applicable codes enforced within the city. 2, is unfit for human habitation or commercial, industrial, or business use or occupancy due to inadequate provisions for ventilation, air, light, sanitation, or open spaces. 3, poses an imminent harm to life or other property due to fire, flood, tornado, hurricane, earthquake, storm, or other natural catastrophe. 4, is vacant and used in the commission of drug crimes. 5, is occupied and used repeatedly for the commission of illegal activities, including facilitating organized crime or criminal enterprises after written notice of the owner of such activities conducted therein. 6, is abandoned. Or 7, otherwise constitutes an endangerment to the public health or safety as a result of unsanitary or unsafe conditions, is hereby declared to be a public nuisance. Every private property within the city on which is being regularly conducted any activity or land use in violation of applicable laws and ordinances, including the zoning and ordinance of the city, is hereby declared to be a public nuisance. Section 24-185, powers of city mayor or his designee. A, in carrying out his duties pursuant to this article, the city mayor and his designee to whom his authority is assigned shall, in addition to those powers or otherwise conferred upon or delegated to him by the charter and other ordinances of the city, be empowered to: 1, investigate and inspect the condition of dwellings, buildings, structures, and private property within the city to determine those structures and property uses in violation of this article. Entries into private property shall be made in a manner so as to cause the least possible inconvenience, provided, however, the public officer shall not enter any occupied dwelling or structure without first having obtained the consent of the owner or a person in possession. In those cases where consent to entry is denied after reasonable request, the public officer may apply to the municipal court for an administrative search warrant upon showing probable cause that a violation exists. 2, to retain experts, including certified real estate appraisers, qualified building contractors, and qualified building inspectors, engineers, surveyors, accountants, and attorneys. 3, to appoint and fix the duties of such officers and employees of the city as he deems necessary to carry out the purposes of this article. And 4, to delegate any of his functions and powers under this article to such officers, employees, and agents as he may designate. B, in addition to the procedures set forth in this article, the city mayor or his designee may issue citations for violations of state minimum standard codes, optional building, fire, life safety, and other codes adopted by ordinance, and conditions declared to constitute a public health or a safety hazard or general nuisance, and to seek enforcement of such citations before the municipal court prior to issuing a complaint in rem as provided by this article. Nothing in this article shall be construed to impair or limit in any way the power of the city to define and declare nuisances and to cause their removal or abatement by other summary proceedings. Section 24-186, complaint in rem in municipal court, procedure, lien, appeal. Whenever a request is filed with a public officer by a public authority or by at least 5 residents of the municipality charging that any dwelling, building, structure, or property is unfit for human habitation, or for commercial, industrial, or business use not in compliance with applicable codes, is vacant, is being used in commission of a drug crime, or constitutes an endangerment to the public health or safety as a result of unsanitary or unsafe conditions. The public officer may make an investigation or inspection of the specific dwelling, building, structure, or property and make a written report of his findings. Such officer shall be guided in his investigation by documenting conditions which include but are not limited to 1, defects therein increasing the hazards of fire, accidents, and other calamities. 2, lack of adequate ventilation, light or sanitary facilities. 3, dilapidation. 4, disrepair by failure to conform to applicable codes and ordinances. 5, structural defects by which render the structure unsafe for human habitation or occupancy. 6, uncleanliness. Or 7, presence of graffiti which is visible from adjoining public or private property. If the public officer's investigation or inspection identifies that any dwellings, building, structure, or property is unfit for human habitation, or for commercial, industrial, or business use, and is not in compliance with applicable codes, is vacant and being used in connection with the commission of a drug crime, or constitutes endangerment of the public health or safety as a result of unsanitary or unsafe conditions, the public officer shall file a complaint in rem in the municipal court of the city against the lot, tract, or parcel of real property on which such dwelling, building, or structure is situated, or where such public health hazard or general nuisance exists, and shall cause summons and copy to the complaint to be served on the interested parties. In such dwelling, building, or structure, the complaint shall identify the subject real property by the appropriate street address and the official tax map reference, shall identify the interested parties, state the particularity of the factual basis for the action, and contain a statement of the action sought by the public officer to abate the alleged nuisance. The summons shall notify the interested parties that a hearing will be held before the municipal court at a date and time certain, and at a place within the county or municipality where the property is located. Such hearing shall be held not less than 15 days nor more than 45 days after the filing of the complaint at the proper court. The interested party shall have a right to file an answer to the complaint and appear in person or by attorney and offer testimony at the time and place fixed for the hearing. C, if after such notice and hearing the court determines that the dwelling, building, or structure in question is unfit for human habitation, or is unfit for its current commercial, industrial, or business use and not in compliance with applicable codes, is vacant and is being used in connection with the commission of drug crimes, or constitutes an endangerment to public health and safety as a result of unsanitary or unsafe conditions, the court shall state in writing findings of fact in support of such determination, and shall issue and cause to be served upon the interested parties that have answered the complaint or appeared at the hearing in order. 1, if the repair, alteration, or improvement of the said dwelling, building, or structure can be made at a reasonable cost, and in relation to the present value of the dwelling, building, or structure, requiring the owner within the time specified in the order to repair, alter, or improve such dwelling, building, or structure so as to bring it into full compliance with the applicable codes relevant to the cited violation, and if applicable, to secure the closing the structure so that it cannot be used in connection with the commission of drug crimes, or 2, if the repair, alteration, or improvement of said dwelling, building, or structure in order to bring it into full compliance with applicable codes relevant to the cited citation violations cannot be made at a reasonable cost and relevant to the present dwelling, value of the dwelling, building, or structure, requiring the owner within the time specified in the order to demolish and remove such dwelling, building, or structure and all debris from the property. For the purposes of this section, the court shall make its determination of reasonable cost in relation to the present value of the dwelling, building, or structure, without consideration of the value of the land on which the structure is situated. Provided, however, that the cost of preparation necessary to repair, alter, or improve the structure may be considered, and proving further that if the unsatisfactory condition is limited solely to the presence of graffiti, the dwelling, building, or structure shall not be ordered demolished or closed, but its owner may be ordered to repair the same by cleaning or removal of the graffiti. Income and financial status of the owner shall not be a factor in the court's determination. The present value of the structure and the cost of repair, alteration, or improvement may be established by affidavits of real estate appraisers with the Georgia appraiser classifications provided in OCGA Title 43, Chapter 39A, qualified building contractors or qualified building inspectors without actual testimony presented. Cost of repair, alteration, or improvement of the structure shall be the cost necessary to bring the structure into compliance with the applicable codes relevant to the cited citations in force in the jurisdiction. D. If the owner fails to comply with an order to repair or demolish the building structure or dwelling, building, or structure, the public officer shall cause such dwelling, building, or structure to be repaired, altered, or improved, and to be vacated, enclosed, or demolished within 270 days of the expiration of time specified in the order by abatement by the owner. Any time during which such action is prohibited by a court order issued pursuant to subsection C of this section, or any equitable relief granted by a court of competent jurisdiction shall not be counted towards the 270 days in which such abatement action shall commence. The public officer shall cause to be posted on the main entrance of the building, dwelling, or structure a placard with the following words, quote, "This building is unfit for human habitation or commercial, industrial, or business use and does not comply with the applicable codes or has been ordered secured to prevent its use in connection with drug crimes or constitutes an endangerment to the public health or safety as a result of unsanitary or unsafe conditions, period. The use or occupation of this building is prohibited and unlawful," end quote. E. If the public officer has the structure demolished, reasonable effort shall be made to salvage reusable materials for credit against the cost of demolition. Proceeds of any monies received from the sale of salvaged goods shall be used or applied against the cost of the demolition and the removal of the structure, and proper records shall be kept showing the application of the sales proceeds. Any such sale of salvaged materials shall be made without the necessity of public advertisement and bid. The public officer and the governing authority are relieved of any and all liability resulting from or occasioned by the sale of any such salvaged materials, including without limitation defects in such salvaged materials. F. The amount of the cost of demolition, including all court fees, appraisal fees, administrative costs incurred by the tax commissioner, and all other costs necessarily associated with the abatement action, including restoration to grade of the real property after demolition, shall be a lien against the real property upon which such cost was incurred. G. The lien provided for in subsection E shall attach to the real property upon the filing of a certified copy of an order requiring repair, closure, or demolition in the office of the clerk of the Superior Court in Tattnall County, and shall relate back to the date of the filing of the lis pendens notice required under subsection A. The clerk of the Superior Court shall record and index such certified copy of the order in the deed records of the city and shall enter the lien on the general execution docket. The lien shall be superior to all other liens on the property, except liens for taxes to which the lien shall be inferior. It shall constitute in force and shall continue in force until paid. After filing a certified copy of the order with the clerk of Superior Court, the public officer shall, within 90 days of the completion of repairs, demolition, or closure, forward a copy of the order and its final statement of cost to the county tax commissioner. H. It shall be the duty of the county tax commissioner to collect the amount of the lien in conjunction with the collection of ad valorem taxes on the property, and to collect the amount of the lien as if it were a real property ad valorem tax, using all methods available for collecting real property ad valorem taxes, including specifically OCGA section 48.45, provided, however, that the limitation of OCGA section 48.478, which requires 12 months delinquency before commencing a tax foreclosure, shall not apply. Provided further that the redemption of the property from the lien may be made in accordance with provisions of OCGA section 48.480 and 48.481. The tax commissioner may initiate enforcement of liens imposed under this section at any time following receipt of the final determination of cost from the public officer. The unpaid lien amount shall bear interest and penalties from and after the day of the final determination of cost, and the same amount is applicable to interest and penalties on the unpaid real property ad valorem taxes. I. The tax commissioner shall remit the following collected, or the amount collected, to the governing authority of the municipality whose ordinance is being enforced. The tax commissioner may retain an amount equal to the cost of administering collection of the lien. Any such amount collected and retained for administration shall be deposited in the general fund of the county to pay the cost of administering the lien. J. The governing authority may waive and release any such lien imposed on property upon the owner of such property, entering into the contract with the municipality, agreeing to the timetable for rehabilitation of the prone property or dwelling, building or structure on the real property and on the property, and demonstrating the financial means to accomplish such rehabilitation. K, review of a court order requiring the repair, alteration, improvement, or demolition of a dwelling, building, or structure shall be by direct appeal to the Superior Court under OCGA, Section 5329, Section 24-187, service of complaints or orders upon owners and parties in interest. A, summons and copies of the complaint shall be served in the following manner. In all cases, copy of this complaint summons shall be conspicuously posted on the subject dwelling, building and structure or property within 3 business days of filing the complaint, and at least 14 days prior to the date of the hearing. 2, at least 14 days prior to the date of the hearing, the public officer shall mail copies of the complaint and summons by certified mail or statutory overnight delivery, return receipt requested to all interested parties whose identities and addresses are readily ascertainable. Copies of the complaint and summons shall also be mailed by first-class mail to the property address and to the intention of the occupants, if any. 3, for interested parties whose mailing address is unknown, a notice stating the time, date, and place of the hearing shall be published in the newspaper in which the sheriff's advertisements appear in such county once a week for 2 consecutive weeks prior to the hearing. And 4, a notice of list pendant shall be filed in the office of the clerk of Superior Court, which lists the dwelling, in which the dwelling, building, structure, or property is located at the time of filing of the complaint in municipal court. B, the public officer shall cause an affidavit of service to be filed of record in the municipal court prior to the hearing showing compliance with the service requirements of this section. Such affidavit shall constitute a prima facie case following showing of minimum procedural due process and shall constitute sufficient proof that the service was perfected. C, orders and other filings made subsequent to the service of the initial complaint shall be served in the manner provided in this section on every interested party who answers the complaint or appears at the hearing. Any interested party who fails to answer or appear at the hearing shall be deemed to have waived all further notice in the proceedings. Section 24-188. Limitation of liability for code enforcement, no special duty created. It is the intent of this article to protect the public health, life, safety, and general welfare of properties and occupiers of buildings and structures within the city in general, but not to create any special duty or relationship with any individual person or to any specified property within or without the boundaries of the city. Approval of a permit and inspection of the property shall in no manner guarantee or warrant to the owner or occupants thereof that said property has been constructed, maintained, or operated in conformance with applicable codes, laws, and regulations. The city reserves the right to assert all available immunities and defenses in any action seeking to impose monetary penalties upon damages upon the city, its officers, employees, and agents arising out of any alleged failure or breach of duty or relationship as may now exist or hereafter be created. To the extent that any federal or state law, regulation, or ordinance requires complete compliance as a condition precedent to the issuance of the permit, plan, or design approval, inspection, or any other activity by the city, its officers, employees, and agents, issuance of such permit or inspection shall not be deemed to constitute a waiver or estoppel of the condition precedent. And it shall remain to the obligation and responsibility of the owner, his design professionals, and contractors to satisfy such legal requirements. Section 24-189, general cleanliness of premises. The owner and occupant of property within the city shall each be independently responsible for keeping the premises, including all buildings thereon, the full yard thereof, clean and free from all garbage, refuse, filth, dirt, ashes, trash, rubbish, and other offensive materials. Section 24-190, disorderly house. A, any person who keeps and maintains, either by himself or others, a common, ill-governed, and disorderly house to the encouragement of gaming, drinking, illicit drug activity, or other misbehavior, to the common disturbance of the neighborhood or orderly citizens, shall be guilty of an offense against the city, provided, however, before any person is charged under this subsection, written notice shall be given the owner of the property and to the person in possession thereof by the chief of police, stating the general, customary, and common habits of the house, giving fair notice of this subsection and the conduct prescribed thereby. B, any person who shall allow any boisterous, noisy, drunken, or riotous persons to assemble or maintain at their house, apartment, or upon their property after receiving oral notice from a police officer that boisterous, noisy, drunken, or carousing activities have caused complaint and annoyance to the common disturbance of the neighborhood, or orderly citizens shall be guilty of an offense against the city, provided, however, no person shall be charged under this subsection unless the owner or person in possession of the premises has been afforded an opportunity to disperse the assembly or offending person from the premises. This subsection shall not preclude a police officer from arresting any individual for criminal trespass where such individual knowingly and without authority remains on private property after being notified by the owner or lawful occupant to depart. Section 24-191, violations, enforcement penalties. Any person who willfully refuses to comply with the provisions of this article shall be cited to appear before the municipal court and, upon conviction, shall be fined not less than $1,000. Each day of continued violation after citation shall constitute a separate offense. In addition to the foregoing fines, upon conviction, the director shall discontinue the public water supply at any premises thereon upon which there is found to be a cross connection, auxiliary intake, bypass, or interconnection, and such service shall not be restored until such cross connection, auxiliary, bypass, or interconnection has been discontinued. Section 24-192, miscellaneous. A, all ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. B, if any section, clause, sentence, or phrase of this ordinance is held to be invalid or unconstitutional by any court of competent jurisdiction, then said holding shall in no way affect the validity of the remaining portions of this ordinance. C, except as modified herein, the code of the city of Reidsville, Georgia is hereby reaffirmed and restated. Codifier is hereby granted editorial license to include this amendment in future supplements of the said code by appropriate section, division, article, or chapter. D, this ordinance shall become effective immediately upon its adoption by the city council. Section 24-192 through 24-200 reserved. That would be ordinance 1. Now we're on to the City of Reidsville blighted property ordinance. Give me just a second, y'all.
It has to be put up on.
Any questions?
Is this the first reading?
Yes, this is the first reading.
And when would this show up on Unicode?
It'll show up on Unicode as soon as it's adopted. It'll give it a day or two after adopted. And I'll be glad to give anybody who wants a copy of this. Just let me know afterwards and I'll email you a copy of it or make a copy and it'll be available.
You need to take a break and catch your breath.
I'm good, man.
Anybody?
I sent my husband a text to bring me another water and let's see what he said on the way. Okay.
I think you're gonna need a Red Bull,
Yeah.
not just a water.
Ain't that the truth? Alright. Be it ordained by the mayor and council of the city of Reidsville, Tackle County, Georgia as follows. Section 1. Chapter 24, Article 3 of the Municipal Code of the city of Reidsville is amended by adding a new division to be numbered Division 5, which shall include the following language. Section 24-201, short title. This article shall be known as the City of Reidsville Blighted Property Ordinance. Section 24-202, purpose. The existence of the real property which is maintained in a blighted condition increases the burden of the state and local government by increasing the need for government services, including but not limited to social services, public safety services, and code enforcement services. Rehabilitation of blighted property decreases this need for such government services. In furtherance of its objective to eradicate conditions of slum and blight within the city, this Board of Commissioners, in the exercise of the powers granted to municipal corporations as chapter, we need to change this Board of Commissioners to the City Council. My apologies for not catching that earlier. The City Council. In exercise of the powers granted to municipal corporations at Chapter 61, Urban Redevelopment of Title 36 of the Official Code of Georgia annotated, has designated those areas of the city where conditions of slum and blight are found or more likely to spread. In recognition of the need for enhanced governmental services and in order to encourage private property owners to maintain their real property and the building structures and improvement thereon in good condition and repair, and as an incentive to encourage community redevelopment, a community redevelopment tax incentive program is hereby established as authorized by Article 9, Section 2, Paragraph 7D of the 1983 Constitution of the United States, Constitution of the State of Georgia. Section 24-203, definitions. A, blighted property. Blighted or blight means any urbanized or developed property which, 1, presents 2 or more of the following conditions. A, uninhabitable, unsafe, or abandoned structure. B, inadequate provision for ventilation, light, air, or sanitation. C, an imminent harm to life or other property caused by fire, flood, hurricane, tornado, earthquake, storm, or other natural catastrophe, respecting which the governor has declared a state of emergency under the state law or has certified the need for disaster assistance under federal law, provided, however, this division shall not apply to property unless the relevant public agency has given notice in writing to the public officer regarding specific harm caused by the property and the owner has failed to take reasonable measures to remedy the harm. D, a site identified by the Federal Environmental Protection Agency as a Superfund site pursuant to 42 USC Section 9601 et sec, or having an environmental contamination to an extent that requires remedial investigation or a feasibility study. E, repeated illegal activity on the individual property of which the property owner knew or should have known. Or F, maintenance of the property is below state, county, or municipal code for at least 1 year after written notice of the code violation to its owner. And 2, is conducive to ill health, transmission, disease, infant mortality, or crime in the immediate proximity of the property. Property shall not be deemed blighted solely because of aesthetic conditions. B, building inspector means a certified inspector possessing the requisite qualifications to determine minimal code compliance. C, community redevelopment means any activity, project, or service necessary or incidental to achieving the redevelopment or the revitalization of a redevelopment area or portion thereof designated for redevelopment through an urban redevelopment plan or through local ordinances relating to the repair, closing, or demolition of buildings and structures unfit for human habitation. D, governing authority means city council of the city of Reidsville, a Georgia municipal corporation. E, millage or millage rate. Millage or millage rate means the levy and mills which is established by the governing authority for the purpose of refinancing in whole or in part the levying jurisdiction's general fund expenses for the fiscal year. F, person means such individual, partnership, or corporations, business entities, and associations which return real property for ad valorem taxation or who are dischargeable by law for the taxes on the property. G, public officer means city mayor or other such officer employee of the city is designated by the city mayor to perform the duties and responsibilities herefore set forth in this article. Section 24-204, ad valorem tax increase on blighted property. A, there is hereby levied on all real property within the city which has been officially identified as maintained in a blighted condition an increased ad valorem tax by applying a factor of 7 to the millage rate applied to the property, so that such property shall be taxed at a higher millage rate generally applied to the municipality or otherwise provided by general law. However, real property in which there is situated a dwelling house which is being occupied as the primary residence of one or more persons shall not be subject to official identification as maintained in a blighted condition and shall not be subject to increased taxation. B, such increased ad valorem tax shall be applicable and reflected in the first tax bill rendered following the official designation of a real property as blighted. C, revenues arising from the increased rate of ad valorem taxation shall upon receipt be segregated by the city mayor or his designee and shall be used only for community redevelopment purposes as identified in an approved urban redevelopment program, including defraying the cost of the city's program to close, repair, or demolish unfit buildings and structures. Section 24-205, identification of blighted property. In order for a parcel of real property to be designated as maintained in a blighted condition and subject to increased taxation, the following steps must be completed. 1, an inspection must be performed on the parcel of property. In order for an inspection to be performed, A, a request may be made by the public officer or by at least 5 residents of the city for inspection of a parcel of property. Said inspection be based on the criteria delineated in the ordinance. Or B, the public officer may cause a survey of existing house conditions to be performed or may refer to any such survey conducted or finalized within the previous 5 years to locate or identify any parcels which may be in a blighted condition and for which a full inspection should be conducted to determine if that parcel of property meets the criteria set out in this article for designation as being maintained in a blighted condition. 2, a written inspection report of the findings for any parcel of property inspected pursuant to subsection 1 above shall be prepared and submitted to the public officer. Where feasible, photographs of the conditions found to exist on the property at the date of the inspection shall be made and supplement the inspection report. Where compliance with minimum construction, housing, occupancy, fire, and life safety codes in effect within the city are in question, the inspection shall be conducted by a certified inspector possessing the requisite qualifications to determine minimal code compliance. 3, following completion of the inspection report, the public officer shall make a determination in writing that a property is maintained in a blighted condition as defined by this article and is subject to increased taxation. 4, the public officer shall cause a written notice of his determination that the real property at issue is being maintained in the blighted condition to be served upon persons shown in the most recent tax digest of Tatnall County is responsible for payment of the ad valorem taxes assessed thereon. Provided, however, that where through the existence of reasonable diligence it becomes known to the public officer that the real property has been sold or conveyed since publication of the most recent digest, written notice shall be given to the person known or reasonably believed to then own the property or to be chargeable with the payment of ad valorem taxes thereon at the best address available. Service in the manner set forth by OCGA section 41.2.12 shall constitute sufficient notice that the property's owner or person chargeable with payment of ad valorem taxes for purposes of this subsection, except that posting of the notice on the property will not be required. B, the written notice given to the persons chargeable with the payment of ad valorem taxes shall be notify the person of the public officer's determination the real property is being maintained in a blighted condition and shall advise such person of the hours and location at which the person may inspect a copy of the public officer's determination with any supporting documentation. Persons notified that real property of which the person is chargeable with payment of ad valorem taxes shall have 30 days from the receipt of the notice of which to request a hearing before the city's municipal court. Written request for a hearing shall be filed with the public officer and shall be date stamped upon receipt. Upon receipt of the request for a hearing, the public officer shall notify the municipal court and the building inspector or person who performed the inspection and prepare the inspection report. C, within 30 days of the receipt of a hearing request for a hearing, the municipal court clerk shall set a date, time, and location for the hearing, shall give at least 10 business days notice to the persons requesting the hearing. The public officer and the building inspector or person who performed the inspection and prepared the inspection report. Notice of scheduled hearing shall be published as a legal advertisement in the Tatnall Journal-Sentinel or other designated legal organ in Tatnall County at least 5 days prior to the hearing. Hearings may be continued by the municipal judge upon request of any party for good cause. D, at the hearing, the public officer shall have the burden of demonstrating by preponderance of the evidence that the subject property is maintained in a blighted condition as defined by this article. The municipal court judge shall cause a record of the evidence submitted at the hearing to be maintained and hearing from the public officer and or their witnesses and the persons making the hearing and or their witnesses. The judge of the municipal court shall make a determination either affirming or reversing the determination of the public officer. The determination shall be in writing and copies thereof shall be served on the parties by certified mail or statutory overnight delivery. Determination by the court shall be deemed final. A copy of such determination shall also be served upon the tax commissioner of Tatnall County, who shall include the increased tax on the next regular tax bill rendered on behalf of the city. Persons aggrieved by the determination of the court confirming the determination of the public officer may petition the Superior Court of Tatnall County for a writ of certiorari within 30 days of issuance of the court's written determination. Section 206, remediation or redevelopment. A, a property owner or person who is chargeable with the payment of ad valorem taxes on real property which has been officially designated pursuant to this article as property maintained in a blighted condition may petition the public officer to lift the designation upon complete proof of compliance with the following. 1, completion of work required under a plan of remedial action or redevelopment approved by the city's planning or redevelopment act director, which addresses the conditions of blight found to exist on or within the property, including compliance with all applicable minimum codes. Or 2, completion of work required under a court order entered in a proceeding brought pursuant to this chapter, if any. 3, any outstanding ad valorem taxes, state, school, county, and city, including the increased tax pursuant to this ordinance, and government liens due and payable to the property must be satisfied in full. B, before action on a petition to lift the designation, the public officer shall cause the property to be thoroughly inspected by a building inspector who, by written inspection report, shall certify that all requisite work has been performed to applicable code in a workmanlike manner in accordance with the specifications of the plan for remedial action or redevelopment or applicable court order. Upon finding written work to be required work to be satisfactorily performed, the public officer shall issue a threatened determination that the real property is no longer maintained in a blighted condition. Copies of this determination shall be served upon the persons chargeable with payment of ad valorem taxes and upon the tax commissioner of Tatnall County. All plans for remedial action and redevelopment shall be in writing, signed by the persons chargeable with the payment of ad valorem taxes on the real property and the mayor or his designee, and include the following, contain the following. 1, the plan shall be consistent with the city's comprehensive plan and all laws and ordinances concerning governing the subject property, and shall conform to any urban redevelopment plan adopted for the area within which the property lies. 2, the plan shall set forth in reasonable detail the requirements for repair, closure, demolition, or restoration of existing structures in accordance with minimal state-wide codes where structures are developed or demolished. The plan shall include provisions for debris removal, stabilization, and landscaping of the property. 3, on parcels of 5 acres or greater, the plan shall redress the relationship with the local objectives respecting land use, include traffic, public transportation, public utilities, recreational and community facilities, and other public improvements. 4, the plan shall contain verifiable funding sources which will be used to complete its requirements and to show the feasibility thereof. 5, the plan shall contain a timetable for completion of required work. And 6, the outstanding ad valorem taxes, state, school, county, and city, including the increased tax pursuant to this article, and the governmental liens due and payable on the property must be satisfied in full. Section 24-207, decrease of tax rate. A, real property which has had its designation as maintained in a blighted condition removed by this public officer is provided in this article. Identification of blighted property of this article shall be eligible for a decrease in the rate of city ad valorem taxation by applying the factor of 0.5 to the city millage tax applied to the property, so that the property shall be taxed at a lower millage rate than the millage rate generally applied to such property in the municipality and otherwise provided by general law. Such decreased rate of taxation shall be applied beginning with the next bill rendered following removal of official designation of a real property as blighted. The decreased taxation may be given in successive years depending on the annual cost expended by the person chargeable with payment of ad valorem taxes on the property to satisfy its remediation or development, with every $25,000 or portion thereof equaling 1 year of tax reduction, provided, however, that no property shall be entitled to reduction in city ad valorem taxes for more than 4 successive years. B, in order to claim entitlement for a decreased rate of taxation, the persons chargeable with the payment of ad valorem taxes on the property shall submit a notarized affidavit of the public officer, supported by receipts or other evidence of payment to the amount expended. Section 24-208, notice to tax commissioner. It shall be the duty of the public officer to notify the tax commissioner of Tattnall County in writing which is to the designation or removal of designation of a specific property as maintained on a blighted condition. Such notice shall identify the specific property by street address and that tax map, block and parcel number as identified by the Tattnall County Tax Assessor's Office. Public officer shall cooperate with the tax commissioner to assure accurate tax billing of those properties subject to increased or reduced ad valorem taxation under this article. Section 24-209, miscellaneous. All ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. Any section, clause, sentence, or phrase of this ordinance is held to be invalid or unconstitutional by any court of competent jurisdiction. This said holding shall in no way affect the validity of the remaining portions of this ordinance. C, except as modified herein, the code of the city of Reidsville, Georgia is hereby reaffirmed and restated. Codifier is hereby granted editorial license to include this amendment in future supplements of said code by appropriate section, division, article, or chapter. D, this ordinance shall become effective immediately upon its adoption by the council. There was one section,
I heard the increase, decrease of tax, right there at the end.
real quick, section 206 needs to read section 24-206. Which one at the end, Nydia?
The increase or decrease of tax.
Decrease of tax rate?
You said which one needs to change?
206, it just didn't have section 204 dash in front of the 206. Yeah, I said just add 24-206 and run that. If you're talking about section 24-207, Nydia,
It was before you did 24-206.
okay.
Need another hit to water.
Is that what you're talking about, the last paragraph, where it should read city council instead of board of commissioners?
No, I fixed that.
That's the only thing I saw.
Increase, decrease of tax.
Yeah, there's an increase. What happens is, if after it's designated as blighted, you increase the millage rate, you multiply it by 7. But it's a multiplied millage rate, whatever their millage rate will be multiplied by 7, and that's the tax penalty they have to pay. They follow all the requirements of the, whatever the mayor, the property evaluator says, and they follow all that. They get the plan, and by that, after that, for the next 4 years, they can pay half of what their millage rate would have been.
Okay.
So it is an increase and then a decrease, so that's correct, yes. So that's the carrot and the stick, you know.
How many
exactly.
days?
It's the opposite though, sticking in the carrot.
Yeah, the stick in the carrot, exactly. What's that?
How many days do they have, how long a period of time do they have to clean it up?
As long as they don't, if they'll keep paying that 7 times the millage rate, they can keep, as long as
If
they
you
want.
send a notice to a property owner, how long before do they have to bring it in?
To appeal it, 30
No.
days.
If you send a notice, how can they clean it up or bring it up to
Yes.
standard before all that takes effect?
Yes, they can appeal it. What they'll do is they'll appeal it to the magistrate court, and then while that appeal is ongoing, they can have time to.
Magistrate and municipal.
Municipal, thank you, municipal court. They'll have time to do it with that. And to be frank with it, to be honest, we've been doing this for years now, and anytime anybody contacts us, we give them time to work on it. You know, it's,
Yeah, I didn't think John Hopkins was involved all of a sudden.
no, he's not. No, you're right about
So
that.
what is the difference between the two ordinances? I mean,
The first ordinance is just the derelict property. We've already got a version of the derelict property
That's what I
ordinance.
thought.
This is the model ordinances that the Georgia Municipal Association wants us to use.
what is the difference between a derelict property and a blighted property?
A blighted property cannot be a property that's used as a primary dwelling. You can't use, if it's somebody's primary dwelling house, if it's their home, you cannot use the blighted property to stick with it. What derelict property, you can. That is a big difference with it. The second of it, the derelict property just allows you to use general nuisance. This is basically what we did with the burns, the complaint in RIM, where you send it and you go in front of the municipal court, and you get it, and you say this is a derelict property, we need to be able to have the cleanup, and you have 270 days to clean it up. The blighted property, you're not cleaning it up, you're just saying it's on you. What we're gonna do is, you have been told that you have blighted property, we have proven that this property is blighted, it's on you now, and as a penalty for you maintaining that blighted property, you have to pay 7 times the taxes you ordinarily would have to pay. And that's the difference on it.
And blighted is usually a home.
No, blighted is usually, it's not usually a home, usually it's commercial property. It can be a home, but not if it's used as somebody's primary residence. If it's somebody's primary residence, you can't do blighted, you have to do derelict.
Okay.
So,
Blighted properties is like these stores uptown.
Yes.
They're empty and got junk out of them.
exactly. Usually blighted is commercial, but not always.
Yeah.
If you've got a home that somebody's not living with, it's an abandoned home, that could be considered blighted, yes.
Several that we're going to.
Yes, exactly. All right, there is one more, and it's not nearly as long. And thank y'all for bearing with me, I appreciate it. Mobile home, I'm sorry, not mobile home, mobile food vendors, a little bit of difference there. Mary, you want me to go ahead and read that one too?
Yes.
Okay.
Get them over here, probably good.
That's my thought, exactly. This is the food truck article, basically. Okay, section 1044-4 definitions. City shall mean the city of Reidsville, Georgia. Hours of operation shall mean the time period from 7 a.m. to 10 p.m. each day of operation. Mobile food vending unit shall mean any motorized vehicle designed to be portable and not permanently attached to the ground from which food is peddled, vended, sold, or given away. Permitted locations. Mobile food vending units are allowed to operate on improved private property only within the following specific location. Private property in the following zoning districts: C1, C2, I1, I2. 2, on property owned or leased by the city and the food is served during an event that is sanctioned and or approved by the city. The City of Reidsville zoning officials will verify all proposed locations for vendor suites that meet the standards for the city's zoning ordinances. Signage shall mean any type of design or artwork that advertises the use of a mobile food vending unit or which contains the name of the mobile food vending unit. Permitted signage. Permitted signage shall mean any signage, marketing, and or advertising any mobile vending unit that meets the following requirements. 1, sandwich board signage located on the premises where the mobile food vending unit is located while the mobile food vending unit is operating. 2, wall signage that is safely affixed to the mobile food vending unit so as to be flat against the surface of that mobile food vending unit. Prohibited signage. Prohibited signage shall mean any signage of any type that is erected or maintained on a right-of-way owned or maintained by the city, by the county, or by the state, and all signage located off the premises where a mobile food vending unit is operating. Section 10, 445, permit requirements. 1, the person or business entity owning or operating a mobile food vending unit shall not operate a mobile food vending unit within the city limits of any permitted location unless or until such person or business entity has obtained a permit from the city. 2, prior to the issuance of the city permit, the person or business entity applying for the permit under each article must show compliance with the following requirements. A, each mobile food vending unit which be engaged in the selling of cooked or prepared food must be licensed by the State of Georgia Health Department. A copy of the license of each mobile food vending unit to be operated within the city limits must be submitted with the permit application. B, each mobile food vending unit that will be operated within the city limits must have a concurrent inspection by the health department, which must be conspicuously posted on the mobile food vending unit. A copy of the current inspection of each mobile food vending unit to be operated within the city limits must be submitted with the permit application. 3, that a mobile food vending unit is licensed by the health department does not guarantee that the city will issue a permit or that the city will approve the mobile food vending unit for any permitted locations. 4, all permit applications submitted under this article must be reviewed and approved by the following departments of the city. A, the permit department, which will verify that all state licensing requirements have been satisfied and that the application is complete. B, the planning and zoning department, which will review the application to ensure that the location and district standard requirements are met. C, the police department, which will review the application, verify if any existing safety violations for the applicant are pending. Section 10, 446, permitted location application. 1, either after receipt of a permit from the city or contemporaneously with the application for a permit, each owner of a mobile food vending unit must obtain approval for each permitted location at which it intends to operate. To obtain such approval, the owner or operator of such a mobile food vending unit to be operated in the city limits must submit an application for the permitted location which requires following information. A, the applicant shall complete and submit to all information required by the application form supplied by the city. B, a copy of either the permit issued by the city or a pending application for a permit with the city. If a copy for the application is submitted, copies of all application attachments must also be submitted. C, a list of all locations at which an applicant intends to operate a mobile food vending unit. D, a location plan of each permitted location at which the owner or operator of a mobile food vending unit intends to operate. That location plan must identify where the mobile food vending unit will be located. Such plan will be no smaller than 8.5 by 11 inches. Each such plan shall illustrate the distance measured from the mobile food vending unit to the building location of the nearest established eating and drinking establishments. E, a written approval of the property owner of record for such occupancy. F, a written statement that the location contains a suitable surface and designated parking spaces for the mobile food vending unit and patrons or customers. G, a signed affidavit from the applicant that the mobile food vending unit will not transport alcoholic beverages to the permitted location and will not sell or give alcoholic beverages at the permitted location to any of its patrons or customers. H, a copy of the mobile food vending unit, liability, insurance, naming the city of Reidsville as an additional insured. Section 10, 447, requirements and restrictions. Failure of an owner or operator of a mobile food vending unit to abide by the following requirements and restrictions shall constitute a violation of this article. Only one mobile food vending unit may be permitted per applicant. 3, a mobile food vending unit shall operate only during the hours of operation. Operation of a mobile food vending unit outside of the hours of operation shall be a violation of this article. 4, a mobile food vending unit shall not operate at any location that is considered to be a permitted location unless and until that mobile food vending unit is approved to be operated at that location by the city. To be approved for any permitted location, each mobile food vending unit must submit an application on forms provided by the city. 5, any mobile food vending unit which begins operating at a permitted location without securing such all permits shall be in violation of this article. 6, a mobile food vending unit shall not arrive to operate at a permitted location more than 30 minutes prior to the time it intends to operate, or prior to 6:30 a.m., whichever is later. 7, a mobile food vending unit shall not stay at a permitted location more than 30 minutes after it is finished operating or later than 10:30 p.m. on that day, on any day, whichever is earlier, unless otherwise permitted by the city. 8, any semi-permanent structure used or associated with a mobile food vending unit operation shall also be removed from the site during hours of non-operation. 9, a mobile food vending unit shall use only permitted signage and shall not use any prohibited signage. 10, all electricity to the mobile food vending unit shall be from a generator or a main power supply via a portable cord that is in compliance with the National Electrical Code. 11, a drive-through shall not be used at any mobile food vending unit. 12, a person operating a mobile food vending unit shall not conduct business with or accept orders from any patrons or customers when such patrons or customers are in their motor vehicles. 13, the area within which a mobile food vending unit is operating shall at all times be kept clean and free from litter, garbage, rubbish, and debris. To that end, each mobile food vending unit must provide a trash or garbage receptacle to which patrons or customers may place their litter or garbage. The receptacle shall be within 10 feet of the mobile food vending unit. The operator of the mobile food vending unit must remove this litter or garbage receptacle and any loose litter or garbage from the permitted location when he or she leaves the permitted location. 14, a mobile food vending unit shall not use amplified music of any type. This restriction shall not apply to the operation of a vehicle used solely as operated solely as an ice cream truck and which does not sell that kind of food. 15, a mobile food vending unit shall not use temporary or portable lighting outside of that necessary to illuminate the inside of the unit and the servicing area of the unit. 16, all the following shall be posted on each mobile food vending unit in a conspicuous place. A, the current business tax receipt. B, a list of the locations at which the mobile food vending unit is permitted to operate. C, a copy of the permit issued by the city. 17, a mobile food vending unit operating at or participating in any event sponsored, authorized, or approved by the city shall pay the registration fees set forth or required by the city or event coordinators. Such fees, if applicable, shall be paid prior to the event. The mobile food vending unit will abide by any and all requirements set forth and by the event. 18, a person who operates a mobile food vending unit shall not go into a park owned or operated by the city, county, or the United States of America to sell, offer for sale, or display a food item unless such person's activity is authorized by a rental agreement or written direct permission of the Director of Parks and Recreation and Department of the city. Let's change Director of the Parks and Recreation to the city to the mayor, since we don't have a. Is that agreeable, everyone?
Change it to what?
Instead of the Director of the Parks and Recreation Department of the city, change it to the mayor. Is that agreeable? Okay. 19, parking requirements and restrictions. A, owners and operators of food vending units shall secure a minimum of 2 dedicated parking spaces for customers utilizing their services. B, parking spaces shall be marked as required by zoning regulations. C, parking spaces shall meet the size requirements established by the city. D, owners and operators of mobile food vending units shall not sell to customers in areas designated as public rights of way. Section 10, 448, enforcement. The provisions of this article may be enforced through the city's code enforcement procedures or as otherwise authorized in this code and may be pursued by appropriate remedy in a court of competent jurisdiction. The remedies that the city may pursue for a violation include, but are not limited to: 1, any violation of this article may be punishable as provided by law. 2, revocation of the permit of the owner and operator of the mobile food vending unit found in violation of this article. 3, refusal of the city to renew or the permit the owner and operator of the mobile food vending unit found in violation of this article. Section 10, 449, effective date. The effective date of this ordinance shall be the date of its approval by the city council. All ordinances and part of ordinances in conflict herewith are expressly repealed, not repealed. And that would be it.
Would this not be the responsibility of the, code enforcer?
He's involved in it, yes.
He's involved with it, absolutely.
And there, I've had him going and checking on the ones that we have and people that want to bring them in. We've got one over here at Raider's sister now. It's turned into a little bit more than a food truck, but.
No, that's not a food truck, this is permanently a food.
Well, yeah, I understand that, but
Yeah.
yeah, she's, it didn't start out that way, but we're taking care of it.
And,
Let me ask
and
you,
do,
go ahead.
and do it, is this something GMA is updating, or we requested it?
This one came from the city of Lyons, if I'm not mistaken, is that right, Mayor?
Yeah, well, when we started wanting so many trucks, people wanted to come here with vending trucks, had to come up with a, vending ordinance, and, a guy that helped Jason over the city manager in Lyons, they already had a vending one, and, they have several vending trucks over there, so he sent me his, and we basically went by his and redid it to suit our needs, but, yeah, lots of places are just now getting vending, trucks, you know, they're not wanting to invest in a restaurant, and, they're trying their business out first, but we've got another one coming too, it's gonna be close to the Cadence Bank over there, Anderson, what's his first name? Daniel, yeah, Daniel's gonna be putting one there, he's already got his permit, he's later gonna be just hopefully down the road, he's gonna build a full buffet restaurant out on 280, in town, but he wants to try it out there first, serving, you know, meat, chicken, like things and sides, but he's getting ready to bring his in about any day, but he's did his paperwork. Don always goes and looks at it and makes sure it meets the requirements, and all the attachments are filled out, all these attachments to this ordinance.
There's an application for the mobile food vendor license attached to the,
Yeah, and then Don gets those and charges.
So Duane,
Mhm.
first off, I mean, is it, they have to remove that that mobile vending unit at the end of the day, correct?
Yes, they do.
So my question is you have business owners in town that are paying for a business license.
Right.
There's nothing here that says you can only operate a certain number of days. So I could have a food vending truck 5 days a week through the whole business cycle
You good?
and get by with a vending permit and not a business license. And you're operating that as a business
That's
at
right.
some point in time.
That's right, unless we want to put a limitation as to time in it.
Well, I thought I read time was from certain.
6:30 to 10:30.
Not day, but a certain hour.
But not the number of days.
But not number of days,
Not
you're
number
right.
of days.
Yes, ma'am.
How much is the permit?
That I don't know.
If the council goes that,
Council would have to decide.
you could say, you know, business license is so much and a permit for this is so much and juxtapose those against, so maybe they would move into a business, but that'd be cheaper to do that.
Well, and I think,
Maybe I thought we already had a business license for them. You should.
Whatever
They
Mr.
talked about
Preston
it,
just
yeah.
said.
Talked about it, we never went
Put it in
through,
place,
this is
yeah.
like putting it in place.
Are they gonna be paying per day, or are they paying for
Per permit.
month, or?
That's something we can,
We need the admin fees, you mean? We're doing the admin fees?
You talking to me? I just talked to one of the, vendors, and they told me they had a license. They already, you know, checked the city, so I was just,
So we're charging them the same as the business license.
okay. So,
Yeah. And the thing too is this moving it back and forth every day now. Like when the person sets up down here, they have to have a generator, you know. And my understanding was as long as they had their business license and they paid that, but they plan to leave those mobile trucks. That's a permanent business for him. He wasn't planning on taking it.
so do we wanna take that language out?
Yeah, I mean, because people with those, he's not coming here like Chick-fil-A, he's gonna be there
I
every
was
day.
gonna say Chick-fil-A removes,
Yeah, they go.
they leave every day,
He-
but Daniels
he
comes
can
stay.
afford
And I
to
really wouldn't fall
move
under a
them.
mobile vendor.
You know, because that's stationary.
Let's read the definition of mobile vendor.
But see, this, he's not gonna be much.
It would though, because the definition of mobile vendor is, mobile vending unit is mobile food vending unit shall mean any motorized vehicle designed to be portable and not permanently attached to the ground in which food is peddled, vended, sold, or given away. It's not permanently attached.
right, and we have a vendor that comes here, they move it every day.
Even if you don't move it every day, if it's not permanently attached, it doesn't fall into, it would fall into the limit of mobile food
Says-
vending unit. No, even if you're talking about like Daniel, for example, he would fall into the category of mobile food vending unit because he's not permanently attached to the ground.
He's going to be.
He is going to be permanently attached.
He's building on the back part to store his cold stuff. He's gotta have a room to store his stuff.
So that's permanently attached.
Refrigerator and everything.
Then that would not fall under the category
So,
of mobile food.
yeah.
Kinda like Raiders place, it's just
Yeah.
a place that doesn't fall under.
No, because it's permanently affixed.
Have to have a
I
business.
charged him for a permit.
So we're okay with that.
Yeah, cause it gave you a certain times, you gotta be in and out.
And what was it, that you alluded to that, with the ice cream trucks?
The ice cream truck can play music, otherwise they can't play music, is that what it is? Unless y'all want to allow them to play music.
Is there a certain kind?
Music attracts some kids.
I don't think I have to.
Do y'all want to strike it about amplified music and let them play music or not?
No.
No music except an ice cream truck can play the ice cream.
Yeah.
Even they-
Ice cream music.
So we're calling Daniels a permanent fixture, that's the way we've done it, and that's what we made it pay for.
And this is gonna be by the, Cadence Banker, the old time
Yes,
spice place over there where,
You know, it's gonna be over here where Dan Bennett had those pools, he was gonna build.
that's the old Tom Spice place,
Okay,
yeah.
Anyway, that's what he bought, and also, I don't remember if you read it there or not, but I told Jessica down here, you can't have a drive around, I know that was in there, but you also gotta have at least 2 parking spaces.
Right.
You gotta have at least 2 parking spaces, and I think she was trying to get a drive around, and that's not gonna be approved. And, cause she can't have a drive around that food, even though that's not a time fixture, she's got a window there, but she wants to put a drive-through around, and there's no way that you can, that you can drive around that place and come back out.
But Jessica wouldn't be covered by this.
Yeah,
She started off.
she started out with a food truck license, then it got bigger, I had to go back and say, no, that's not a food truck, so then we had to go back again and measure and like, she said, well, it's not a permanent fixture because they got no blocks. True enough, but, you know, it's not a food truck either. So you have to just kind of,
I would say that she's not a mobile food vending unit because it's designed to be permanently attached to the ground.
She's got water
She's got water.
She'd have to have.
hooked up to her building.
She'll have to have business license and she would be able to have a drive-through under this.
If she's an attached, I think the
Yes.
requirement is that you have to have a drive-through now since COVID.
that, she doesn't consider herself attached.
She's gonna have to elect one way or the other.
Now, I don't know.
She's gonna have to elect.
It's back and forth, but
If-
we'll get it.
If she elects to be permanently affixed, she can have a drive-through. If she elects not, then she could. That's how I read it.
That little white house is on
There's not enough room for that, is there?
Good enough.
Alright. And I'm done, oh, I'm sorry.
We still hadn't answered, I mean, if they're operating 5 days a week, that's a business, whether it's mobile or it's not mobile. I think it's unfair to our business owners in town to have to pay a business license, and then possibly a food vending truck operating 5 days a week. It's a lesser
Should be
fee.
a full.
Well,
He's gonna do a business license.
I'm not talking about just him, I'm talking about the ordinance itself needs to be some guideline there.
So there needs to be-
Clarification of some kind.
How long is the permit good for, Joanne?
I guess it would be good for a year like every other permit would be good
Yeah.
for.
I was gonna say, that probably needs to be in the ordinance.
You don't have any distinguishing between like somebody coming in for like a festival and having a food truck set up for a week or 3 days or whatever the festival lasts for versus a full permanent business license?
There's no distinction unless we had a sliding scale permit
First.
fee, and that's what I would recommend is that we have a sliding scale permit fee.
That'll take care of what Don's worried about.
Well, how the business permits work is that we charge them like for however how many employees they have, but if they're a small business like Jessica's, she wouldn't be able to have as many employees, so her license still wouldn't be as much.
Don't you have to have a business license, you have to have a certain number? Of employees?
Yes, ma'am. Like,
You're charged per employee.
That's what I'm saying, you charge
Yeah.
per employee,
Uh-huh.
yeah. And,
Let's see where it talks
so
about.
you just got
the first, I think it's the first 10
10, the first 10, yeah.
I mean, like the arts and crafts show, the wireless thing, that's what, 2 days or 3 days?
Right.
But what Don was asking is if they stayed for 5 days, would they have to pick up and move and?
Well, my thing is, if they're operating it like a business
Yeah,
every day of the week.
But the other thing you gotta look at with food trucks is a lot of times they're seasonal too, like if, you know, during the winter time, they may not have their trucks out because of the temperature, right? I came from Chicago and food trucks are a huge industry up in Chicago. And during the summertime, food trucks are everywhere, during the wintertime, obviously Chicago's a lot colder, a lot of snow and stuff like that. But during the wintertime, you don't see a food truck.
well, here's the other thing, is it also fair to make them pay a higher cost when they have to get a business license in every city that they're in? So just like Benet's, they come once a week, so they have to get a business license versus.
Well, that's not what I'm saying, that's one day a week. But you have the possibility of somebody coming in and setting up a food truck every day of the week and operating it like a business.
That's a business.
And there needs to be some distinction there.
I think I've got some language here.
Well, how about Nikki's place over here? She runs her business 2 days a week.
But she's permanently fixed.
Yeah.
How about this language, right here, and we've got section 10-445 permit requirements. It says the person or business entity owning or operating a mobile food vending unit shall not operate a mobile food vending unit within the city limits at any permitted location unless and until such person or business entity has obtained a permit from the city. How about we add this language? The permit fee charged by the city shall be based upon the frequency of operation in the city on a sliding scale determined by the city. How about that?
Cause Ms. Vicky, didn't you say Coward said if they came, they were gonna start off in their food truck and then go to a permanent?
Yeah, but they would stay here a good while, kinda like Daniels doing down here, cowards from, Hagen, would bring their truck for.
If we add that language, Donald, what we could do is the council could vote on what that sliding scale would be, and it wouldn't have to be, you don't want to put that in your, ordinance anyway, but that just says that it'll be based, the fee charge will be based on the frequency of operation. So that gives you
And
that.
then the code enforcement would monitor that?
Code enforcement will what?
Monitor that.
Yes, yes. So they could be here for 1 day, 5 days, 7 days,
Yes.
30 days.
Right.
You could have it, yeah.
And the sliding
For
scale
1
would
day would be $20, I'm just,
right.
yeah. 7 days would be
But if they're gonna be
$70.
there, but if they're gonna be there for 5 days, I mean, that's basically a business.
Then
Now,
that
if
would
there's
be,
some craft fair or something in town and it's only here for 5 days, and they're not gonna be here, I mean, the whole point of a mobile food truck is they move around to different
They
places.
follow the fairs is basically.
right.
Yeah, they follow.
Well, I can understand that, but if they come into just, correct me if I'm wrong with that, Vicky, he's gonna be stationary, I mean, this is gonna be permanent.
It's gonna be
Permanent.
Then that makes our
That's
shift
a
regular
different-
business.
That's a business license, yeah.
Yeah, that's when it shifts to another ordinance.
Yeah, yeah.
Or that sliding scale gives the flexibility of saying, if you're gonna be here permanently, not permanently, but if you're gonna be here, say 360 days a year,
Yeah.
then it'll be the same fee as a regular business
Business
fee. If you're gonna be
license,
here 1 day a week, it'll be one fee. If you're gonna be here, 2
5
days in a
days.
year, it's gonna be
Yeah.
a certain fee.
Yeah.
And that
And
way,
and that way it could be monitored, and if they're here longer than that, or whatever it is, then, you know.
we don't wanna have a
Yeah.
chilling effect on bringing these people.
No, that's not what I'm saying, but we can't cut them a break if they're gonna operate like
Sure.
a business, when you have business owners in town that are paying a full business license.
Are y'all okay with that sliding scale language?
I'm good with it.
Yeah.
Yeah.
So you wanna read that again?
Sure.
No. Yes,
Alright, I'm gonna read what the paragraph would be. It'll be, because I'm adding to the paragraph, so I don't have to renumber. Section 10-445 permit requirements. The person or business entity owning or operating a mobile food vending unit shall not operate a mobile food vending unit within the city limits at any permitted location unless and until such person or business entity has obtained a permit from the city. We would add this language: the permit fee charged by the city shall be based upon the frequency of operation in the city on a sliding scale determined by the city. It's not very elegantly phrased, but it'll do.
And that if they say that they're here, continually.
Then they get charged with a business fee
Exactly,
charge.
exactly.
So all that has to be adjusted, just stay on 1 day, 2 days, 3 days,
Yes,
4
ma'am.
days.
But that wouldn't go in the ordinance, so it would go in just, the same thing is that regular permit fees are not in the ordinance.
Right.
They're just determined by the city.
Right.
Once a year, or start of the year,
You
right?
create a fee schedule, yeah.
Right, they'll be scheduled, exactly.
I think business license like have to be renewed.
Sound good?
Sounds good.
Awesome. I'll change that and add that to it for y'all.
You don't want to get money to.
You sure you don't wanna read all that again?
I wanna get a
Just for you,
derelict
Kendra, I'll
property.
be glad to, 4 times later. Ugh.
You may call your husband and bring it up.
Just started a phone meeting today.
That's it, Madam Mayor.
Any questions from anybody? Everybody awake?
Are you, yeah,
Yeah, these food trucks have to be dealt with a little bit differently depending, they start out being one thing and then they add on and they make a permanent thing, so it's just been, we're keeping up with them and, doing the best that we can. And, while we don't have this actually, and, yeah, we're just doing what we can. We're using the forms
session.
So,
you want to get to read them twice, or is that the only time you
Now,
need
you
to?
have to read them once, and then at the second, there's a 2-month period. If you read them the first time, the second time you don't have to read them, they can be voted upon.
That's when it gets voted on.
That's when they're adopted.
I'll make a motion that we go into executive session.